start. Although in some other writ petitions, counter affidavits have also been filed by state and authority, the writ petitions relating to different villages are separately grouped, and it shall be suffice to refer to the pleadings of the main writ petition as well as leading writ petitions of each village along with pleadings of some other writ petitions which were referred to by different learned counsel during the course of hearing for deciding this bunch of writ petitions. The facts as brought on record in the main petition and the reference to the pleadings in the said writ petition are sufficient to comprehend and decide the various issues which have arisen between the parties in these writ petitions. Hence, facts of the case of the main writ petition and pleadings therein shall be noted in some detail. Writ petition number 37443 of 2011, Gajraj and others versus State of Uttar Pradesh and others have been filed by 27 writ petitions who claim transferable right and owner of different plots of land situated in village of district Gautam Buddha Nagar. The notification was issued by the state government under section 4 of 1 of the Land Acquisition Act 1894, notifying that the land mentioned in the schedule is needed for the public purpose, namely for the planned industrial development in the same district through Greater Noida Industrial Development Authority. The petitioners plead in the writ petition that dispensation of the inquiry under section 5A can only be exception where the urgency cannot brook any delay. The respondents, without application of mind, dispensed the inquiry. The acquisition proceedings have been termed as void, unconstitutional, tainted with malefied, abuse of authority, power, and non application of mind. The provisions under section 5A is mandatory and embodied a just and wholesome principle that a person whose property is being or intended to be acquired should have occasion to persuade the authorities that his property be not touched for acquisition. Land use of village Patwari was changed in the master plan after the notification under sections 4 and 5, which is colorable exercise of powers, and entire exercise is arbitrary, illegal, and infringes rights of the petitioners guaranteed under Articles 14, 19, and 300A of the Constitution of India. The petitioners have stated in the writ petition that writ petition is being filed after knowledge that the land use of village Patwari was changed in the master plan after the notification. The petitioners further claimed that the part of the property of the petitioners is situated in village. It is pleaded that the authority has executed a lease deed in favor of respondent number 4, a company engaged in the construction allotting 2040 square meters land for constructing multi-storied complexes. Reference of another writ petition, Dinesh Kumar Garg and others versus State of Uttar Pradesh and others, was made by the petitioners, in which the same notification was under challenge, and this court has passed an order directing the parties to maintain the status quo regarding possession. It has been stated that although land was acquired for industrial development, but the same has been allotted to the builders by the authority, which clearly indicates that neither there was any appropriate plan and scheme for industrial development, nor there was any urgency in the matter, and the whole proceeding was in colorable exercise of power. The state filed a detailed counter affidavit in the writ petition stating that after declaration under Section 6, the possession of land was taken and about 87% of tenure holders have been taken compensation. On 29th January, by an unknown train, deceased Akash was travelling from Nagpur to Chandur railway station in order to go to his home. As the apartment of the train was overcrowded, the deceased was standing near the door of the compartment, and while traveling he fell down from the running train due to sudden jerk on a railway station in front of signal. The deceased died on the spot. The deceased was traveling in the train with poor journey ticket purchased by his friend. Information was given by loco pilot to the station master of the railway station. The body of deceased was cut into pieces. The appellants, the parents of deceased, filed claim before the Railway Claims Tribunal praying to grant compensation. The respondent filed its written statement. Learned Claims Tribunal framed issues. Appellant himself and witness, the Railway Claims Tribunal rejected the claim on the ground that the deceased was not a bona fide passenger and there was no untoward incident as claimed. The learned counsel has submitted that the evidence of the witness shows that he was friend of deceased. The deceased has come to Nagpur. He, along with the deceased and himself, purchased the journey ticket of deceased and handed over to him. He has stated that the compartment in which the deceased was travelling was overcrowded. The deceased was standing in the doorway of the coach. He came to know about the accident. Learned counsel from railway side vehemently argued that the Railway Claims Tribunal has minutely verified the documents and has come to proper conclusion that the deceased might have committed suicide. No journey ticket was found on the spot of incident. He was not a bona fide passenger. Learned counsel has submitted that if the deceased would have fallen from the running train, he would have been thrown by the side of the track. He would not come under the wheel of train. This itself shows that he was run over by train. Therefore, it is not an untoward incident. Deceased learned counsel has submitted that only because the body was found, it could not be inferred that it was suicide and not an untoward incident. Learned counsel has further submitted that as per evidence of the witness, deceased was having journey ticket. The ticket must have been lost in the incident. It cannot be a ground for rejecting the claim in view of judgment of Honorable Apex Court. It appears from the judgment of Railways Claim Tribunal that the evidence of only railway station was relied on. Admittedly, he was not an eyewitness of the incident. As per his evidence, he was informed by loco pilot of train that dead body of an unknown person was lying in front of home signal. In the cross-examination, he has admitted that he did not receive any information from any authority that someone has committed suicide or was ran over by train while crossing the track. On personal perusal of the written statement filed by the railways, signed by senior circle security inspector, it appears that after complete investigation, it was found that the deceased was not travelling with a valid ticket. The deceased was travelling in the door of coach. Therefore, the incident took place. If the deceased would have travelled sitting in the coach, such type of incident could not have taken place. The incident took place due to negligence of the deceased himself, and therefore the railways is not responsible.